Okay, good morning. We're going to start on chapter 2 in domestic relations here, marriage and marriage alternatives. In your blackboard, there are assignments to read this chapter, to discuss a couple of comparisons, and I will be posting a quiz at the end of the week on this chapter. So let's get rolling. So this chapter is about marriage. We talked in our first introductory chapter about the history of marriage. Well, let's dive a little bit deeper into what exactly marriage is. We've talked about the fact that there are secular and religious marriages. And your book goes into the origins of a religious marriage, citing, this is now bone of my bones and flesh of my flesh. She shall be called woman, and she shall be taken out of man. Genesis. Okay, so it is from that biblical passage that organized religion developed the concept of one man, one woman being married. Now, you'll say, I thought in biblical times people had lots of wives. They did. Different cultural world. Take one moment to step back and think about what the world was like 6,000 years ago. And how hard it was to give birth, and how hard it was to raise children. And so there was kind of a sociological kind of way of looking at marriage so that you could continue to procreate, but you didn't have to do it with one wife. And so you'd have multiple wives. And again, it was for this purpose of procreation. The more children you had, the more work you could get, or the more wives you could support, the wealthier you were. And that concept still is in play in a lot of Middle Eastern cultures even today. But in Judeo-Christian American jurisprudence, we narrowed the number of people in a marriage and said, really, we want one man, one woman. And that really came with the Reformation of the church, which again goes back to this whole idea that marriage comes from a religious perspective. And unfortunately, or fortunately, however you want to look at it, the state has interjected itself into that religious purpose and definition. But this is the origin of marriage. So how did marriage develop in Judeo-Christian American jurisprudence? Well, we've talked about the fact that 6,000 years ago, Judaism was born, and through Judaism, you had marriage. And this was the first time that women were treated as something other than chattel. Chattel means property. In the world 6,000 years ago, women were dispensable, right? You would have the children, you would serve the man, and literally they could spit 3 times on the ground and say, I divorce you, I divorce you, I divorce you, and you weren't married. Okay? So in the organization of Judaism, creating a community that would then be self-sustaining and stable, there are rules about women. I like to say it was the first feminist religion, where women were given certain rights. And there are rules about procreation and how women control when there can be physical relations between a man and a woman. And there are rules about, okay, if you want to terminate this marriage, if this is not going to work, we are going to have some guidelines. And thus came the idea of a marriage contract. In Hebrew, it's called a ketubah. You can see my ketubah on the wall behind me. It's a marriage contract. It says, okay, if you guys decide that you are going to terminate this marriage, this is how it's going to be terminated. It is the first prenuptial agreement. Okay? And why is that so significant? Again, because women were viewed as dispensable up until the point in time that a religious organization, Judaism, decided we're not going to do that. That's not right. That's not really what we think marriage should be. And so these rules and guidelines were put into a marriage contract. That's when we first started this idea that an agreement, well, it's not really the first idea. It's how we sort of incorporated this idea of marriage into contract law. If you've taken any of my classes, you'll know that I believe that pretty much everything in the world runs by contract. And what is a contract? An agreement, a mutual understanding, a meeting of the minds, right? We both understand that these are the rules of the road, and we agree to go forward. And so marriage then became a contract with an actual written contract. And that carries through. You know, Christianity picked up on this idea. We then became one man, not one woman in one marriage instead of polygamy, because the world had changed. And we had a marriage contract that was solemnized by the church. And there were rules, right? Some churches required premarital counseling. Some churches required meeting with their clergy once a month. Some churches required basically mentoring or sponsoring by other married couples within that religious order. There were safeguards that were built into the system, right? You're far less likely to terminate a marriage if you've got a little support system, right? You're far less likely to terminate a marriage if there's a meeting of the minds going into the marriage. And by the way, in the Jewish faith, really the rules of the road are pretty bad. If you break your commitment and terminate a marriage, there are pretty onerous penalties that are built into the contract. Why are they there? As a guardrail. Keep everybody married. It's worse to get married to get divorced than it is to stay married. So why don't we work on the marriage? Okay? This idea of till death do we part, again, biblical. If you are of one flesh, then you are one person, and so you stay together until you die. Kind of like geese. Did you know geese do that? They do. So if you're talking about, why this idea of longevity for the entire span of your life came about, it's all very logical. If, again, you go back to the religious roots of traditional marriage in a Judeo-Christian community, society. The purpose of marriage is procreation and to create stability within a community so the community grows. Okay? Now, your book goes into what we've talked about civil marriage. A civil marriage, a secular marriage, a government-sanctioned marriage. I can have a religious marriage and have the government not involved with it at all. In fact, most polygamist marriages are strictly religious. Why? Because the state won't sanction polygamous marriages. At least not yet. They're on the road to doing that, but they haven't done that yet. So a secular marriage A civil marriage is a marriage that fits the guidelines of the government. Now, do we mean the federal government or the state government? Well, I'm going to say both. How can we know? Well, it's kind of a gray area right now, right? The U.S. Constitution provides the guardrails for federal government, for the government that's in Washington, D.C., right? We send representatives there. We have the Supreme Court, we have the executive branch. So that's the federal government. We have state governments, right, that have their own individual flavor. And state governments, according to the U.S. Constitution, are given authority over anything that is not specifically enumerated in the federal Constitution, in the U.S. Constitution. I challenge you to look anywhere in the U.S. Constitution for the word marriage. Spoiler alert, not there. Okay? So, according to the 9th and 10th Amendments to the U.S. Constitution, the concept of putting parameters, governmental parameters on marriage really goes to the state, not to the federal government. However, we have this recent ruling by the U.S. Supreme Court saying that the federal government recognizes or says or is directing, all states that they must allow, sanction, provide for homosexual marriage. Now, that's not because the U.S. Constitution specifically says the word marriage. It's because the Supreme Court interpreted the Equal Protection Clause of the Constitution to say that everybody needs to be treated exactly the same. Therefore, you cannot discriminate against people who are homosexual who wish to be married. Okay? So it's an interpretation of the Equal Protection Clause that the Supreme Court utilized to impose homosexual marriage on all 50 states. Okay? So, who do we listen to? Do we listen to the state? Do we listen to the Supreme Court? Well, we listen to the Supreme Court, obviously. It's the highest court in the land. It governs law for all 50 states. However, the states still have a little bit to say about this. And there are different requirements imposed by different state legislatures in different states. So if I'm in one state, I might have to take a blood test before I'm allowed to get married to make sure I don't have any communicable diseases. Or I might have to undergo a background check to make sure I've never been married before. Or if I have been married, that marriage has been terminated appropriately. In some states, it's as simple as just saying, nope, never been married before, don't have anything, sign here on the dotted line. Every state has its own perspective on what it thinks is important to grant a secular or civil marriage. So why the feds get involved in the first place? Well, again, because there was a push to say that the states can't override the Equal Protection Clause of the United States Constitution, and also because the federal government grants certain benefits based on your marital status. For instance, if I'm in the military and I die, my spouse, my husband, is entitled to certain benefits because we have a civil, legal marriage. Not because we have a religious marriage. Military and the federal government doesn't give a hoot about that. But as far as a legal, civil, secular marriage, there are certain benefits that will go to my spouse. So the definition of what a spouse is kind of important. That's the same thing with Social Security benefits, death benefits, disability benefits. So the federal government has certain benefits that can flow to a surviving spouse or the spouse of an injured person. And so the definition of marriage becomes important. And the same is true with states. So if I live in the state of Ohio and I'm working someplace and I'm injured, I'm entitled to workers' compensation. And what if I die because of those injuries? My spouse is entitled to spousal benefits. from that same workers' compensation board, which, by the way, is run by the state. Okay? And so it's important to understand that there are certain carrots and sticks that are built into each state's system to encourage and punish people if they choose to only have a religious marriage, and it encourages them to have a civil or a secular marriage. If you look on page 19 of your text, there's a whole list of benefits that inure to people who are married, right? Elective share protection, estate and gift tax exemption benefits, family court jurisdiction. We talked about this in the last lecture, where if you have a golden ticket, you can go to domestic relations court and everything goes smoothly because there are statutes written on how to take care of terminating a marriage. If you're outside of marriage, it's a lot tougher. Family leave, the ability to file a joint tax return, guardianship rights, hospital visitation rights, which actually has changed a little bit, immigration benefits, insurance benefits. Again, it kind of depends on the insurance company. Intestate succession protection. I'll come back to that. Joint adoptions and military benefits. Intestate succession protection means if I die without a will, I've died intestate. So how does my stuff get divided up? Well, the legislature has provided for that. It's called intestate succession. If I'm not legally married through a secular civil marriage, even if I've been living with my husband for 50 years and we've called ourselves husband and wife, guess what? We're not married. And he gets nothing. Nothing. So it's important to understand the carrots and sticks that the government has over time put in place to encourage people to not just get a religious marriage, but also get a secular marriage. And you're going to get punished or lose out on benefits if you choose not to. Okay? Now, your book talks about covenant marriage. It's only in Louisiana, so I'm not even really going to bother about that. But it also talks about common law marriage. Boy, we hear that all the time, don't we? We're common law married. People don't know what that means. Okay? Common law marriage in some states is permitted. In Ohio, it's grandfathered in if you held yourself out to be common law married before, I think it's 1982, but you can look that up. So what is common law marriage? In those states that recognize it, it is two people who have held themselves out publicly to the community as being married for a period of time. Now, the period of time can vary from state to state. They'll have a statute to say how long that is. And how do you hold yourself out? Well, it can be in some states as simple as saying, this is my husband, this is my wife. But typically it means that you've done so in writing. So you have a joint bank account, husband and wife. You filed joint tax returns as husband and wife. Those are the kinds of things that will put you over the finish line to say that you actually are married using common law as the basis for your marriage. Again, not many states do it. Ohio used to, but now it's grandfathered. It's grandfathered in. Your book goes in why do you choose common law? My perspective on this is it was an outgrowth of the sexual revolution in the 1960s, where people decided they were going to live together, and then after a while they had kids, and then they were like, geez, we probably should be married. And so common law marriage became kind of a thing. But, you know, it's pretty easy to get married, and it's pretty easy to terminate a marriage, and so the perspective of most states is, get married. It's enough. By the way, you're gypping us out of fees for marriage licenses and and for marriage certificates, so we're not real happy about that. Okay? All right, the next section in the chapter deals with same-sex marriage, and I'm on page 24 of your book. Now, how did we get to the point where the Supreme Court ruled on same-sex marriage? Well, we had situations in different states, and again, different states have different personalities, where state legislatures said, you know what, we will recognize that there is some kind of a legal union between people of the same sex who wish to form a family unit. Okay? They called it different things, but it basically was a recognition that people who are same-sex and homosexual who wish to form family units should not be penalized under the law from getting state benefits or insurance benefits. And so several states started to do this. Civil union was one of them. And basically it gave all of the rights of marriage to homosexual couples without infringing on the religious nature of traditional marriage. It was really hard to get over the hump of marriages between one man and one woman, because that has been the case for 6,000 years. Ultimately, Massachusetts became the epicenter of the homosexual marriage issue, and the case ended up going to the U.S. Supreme Court, and the U.S. Supreme Court said, you know what, under the Equal Protection Clause, guess what? I think you probably can say that you love somebody and that is the real reason for marriage, not all these religious reasons of procreation and stability and those kinds of things. We're not going to recognize that, and we are going to say it's okay. Go ahead and get married. And so it was imposed upon the states. There was an equivalency that was made between slavery and homosexual marriage, saying, you know, just like in the tradition of slavery, states could not individually hold slaves, the same way that individual states can't treat people who are homosexuals differently when it comes to the institution of a civil marriage. It was a stretch in my mind, but that's the way the Supreme Court ruled. It may get revisited, who knows? You know, lots of things get revisited by the U.S. Supreme Court, but the way that the law is right now is, under the Equal Protection Clause of the United States Constitution, states may not discriminate against homosexuals who wish to engage in a civil marriage. That's the history of it. Okay? So, those are some of the backgrounds of where we're at right now, but let's talk about what a valid marriage is. Okay, we know now it can be one man, one woman, or people of the same sex. We know the history of how it got there. So we know states are going to set guidelines. What are those guidelines and where do we find them? Well, each state's legislature, remember the legislature is the law writing portion of your government. Each state's legislature decides what's important to that state's electorate. And so on page 23, you'll see, or I'm sorry, 33, you will see there are some requirements that are written into state statute. It's going to be different from state to state. They'll be very similar, but each state has its own personality. Age requirement. How old do you have to be to get married? The answer is most of the time 18, sometimes 16, sometimes 12. Depends on the state. And if you are younger than 18, you probably have to have your parents sign off on it. But each state has a limit, a basement on how old you have to be before you can get married. Now, why is that? Well, remember we talked about the fact that marriage is a contract. Well, part of contract law is that you have to have capacity and understanding of what you are doing. In most areas of the law, if you're younger than 18, you don't have capacity to enter into any kind of a contract. When I was a kid, the big thing was you could order like 15 records for a penny, and then you were on the hook to buy a record every month for the rest of your life, basically. And every kid, when they hit 15, was like, I'm gonna join Columbia Records, and I'm gonna get all these records. And they would sign the contract, and Columbia Records knew that they shouldn't have done that. These were kids. They had no capacity to enter into the contract, but they thought they made a business decision that parents were going to pay this thing off. Okay? But if a parent said, get out of here, Columbia Records, this is a kid, they can't enter into a contract because they don't have capacity, Columbia Records had to say, yeah, I guess you're right, and go away. So the age requirement for marriage makes sense, again, if you think about marriage as a contractual relationship where everybody knows the rules going in. If you're younger than 18, how can you have capacity to enter into a contract? Doesn't make sense. So that's why if you are younger than 18 in most states, from 16 to 18, with parental permission, you can get married. And again, depending on the state, it could be younger than that. Okay? A blood test requirement. Most states don't have blood test requirements. There are a few that do. And why would they have that? Well, there are some congenital diseases that you can pass on to your kids that if you don't have a blood test, you don't know about it. And then this whole idea of contract is, well, if I didn't know, if I knew that you had sickle cell anemia in your gene pool and we were going to pass that on to our kids, I probably wouldn't have married you. Or if I knew that you had Tay-Sachs in your gene pool that would be passed on to kids, I probably wouldn't have married you because I wanted to have kids, but I didn't want to have that risk. Okay? So some states, in the interest of a full contractual disclosure, require blood tests just to screen. In the 90s, AIDS was the big thing, right? And many states required AIDS screening before you could get married because that's a disease that you can pass on to your partner. So understand that there's a reason it's usually contractual. Most of these reasons are contractual. And it is so that you can have a full meeting of the minds with full disclosure. Okay? The next thing that's in your book is marriage license requirements. What does that mean? Okay, the state can get 2 bites of an apple if they give you a license and then a certificate, so you have to pay twice. Let's just be honest about it. And different states will grant you a license to get married that's good for a period of time or requires that you wait a period of time before you are permitted to get married. Why is that? Again, I'm in love, and then the next day you hate each other, but you're already married. There's a cooling off period, so the state has an interest in preventing needless terminations of marriage by just having a cooling off period. Okay? And then there's a solemnization, I cannot say the word, solemnization requirement, which means there's got to be some kind of ceremony. You've got to have something that says you stand in front of somebody else and in front of a third party and execute this contract, right? Where you stand up in front of somebody that the state says is qualified to accept you two saying that you enter into this contract and then sign off on it. So there's a witness to a contract. Most contracts actually have witnesses. Why? We don't want to have fraud. That's simple. So if we have a third party acting as a witness, and some states require 2 witnesses, some states require 3 witnesses, okay? If we have a witness to the contract, it's harder for the people who entered into the contract to come back and say, I had no idea what I was doing. And the witnesses say, we were there, you looked like you knew what you were doing then. So that's why there is that requirement written into the law. It is basically laws that codify how a contract is entered into. Those are the requirements for a valid marriage. Okay? What about marriages that are performed abroad? Holy tamales. What do we do with these people? They come over and they say they're married. Do we say they're married? Well, most of the time, yes. Right? Unless one of them says, I'm not really married. If somebody raises an issue, say they've been married in a foreign country, and then they come here and they say, you know what? It was a sham. We only did it because our parents made us do it. Or it was a sham. It was under duress. Then the courts have to look at whether the customs and procedures in the foreign country were met. And if they were not met, or if there's an allegation that there was fraud, or an allegation that this was just for show, then the court will deem the marriage not to be a valid marriage. We also have trouble with people who come over here in polygamous marriages, right? If I live in a country in the Middle East where polygamy is permitted, it's encouraged, it's actually a sign of wealth, how many wives do we recognize when they come to the United States? The answer is the first one. Everybody else is not married. So in polygamous marriages that are performed abroad, even if they're performed under valid customs and everybody agrees you're married, if you immigrate to the United States, wife number one is the only wife. Everybody else, not so much. Okay? Your book goes into bigamous and polygamous marriages. We're in a gray area, guys, because lots of litigation in the state of Utah that is going to spill up to the United States Supreme Court in just a matter of time. Whether you can marry more than one spouse, usually a wife. There are certain religious sects that believe that there should never have been a reformation in the church, and that you are basically commanded to have more than one wife because you need to procreate and make a stable society and community, and that's part of their belief system. Okay? So in polygamous marriages, legally there's one wife, everybody else is called a putative spouse. However, again, because we had this ruling from the Supreme Court saying that the basis of marriage is love, it is just a matter of time before the Supreme Court has to say, yeah, if it's a loving polygamous marriage, guess what? We'll have to wait and see. Jury's out on that. Okay? So, that is pretty much this chapter. Oh, no, it's not. I'm sorry. Let's go through cohabitation, because it's one of my least favorite things in the world. Cohabitation is where you decide you're not going to be married, but you're going to act like you are. In my day, we used to call it playing house or shacking up. I know that's not popular, but guess what? I'm old. So with cohabitation, the problem really becomes, how do you split stuff up if you terminate the cohabitation arrangement? Again, it's a contractual arrangement. But there aren't all those safeguards that are built in like there are with marriage, right? We just talked about with marriage, we have to have a minimum age. We have to make sure that everybody's on the same page, that everybody knows the rules, and that there is a witness that says, yep, these people entered into this contract. You know, a lot of people live together because it just makes more sense financially to them. Well, who's the third party that says that everybody understood the rules of the road before somebody decided to keep more than a toothbrush at somebody else's apartment? Right? There are no guardrails at all. So cohabitation's kind of roommate with benefits, and you better hope that everything goes smoothly because splitting up stinks. I've handled many cases where one party has moved out with a child and they're in juvenile court trying to work out custody, and they bought a brand new living room set that the person who's still in the apartment slashes to pieces. You know, because sometimes things don't end well. And what do you do with that? Who pays for that? Who can prove without receipts who paid for that? Who got the benefit of it? Why'd you leave it there? Lots and lots of cohabitation cases where somebody just throws the other person's stuff out onto the sidewalk, usually in the middle of a rainstorm. What do you do about that? You got your stuff. It's ruined, but you got your stuff. Not going to go to domestic relations court. Don't have a golden ticket. Sorry. What are you going to do about that? Go to municipal court? I don't know. It's hard. It's hard. There are no boundaries. There are no contractual boundaries. And even if you do have contractual boundaries, usually both parties don't agree. Okay? There is a case in California where the court said, look, people are all living together and you're giving us really a lot of grief because you're splitting up. So we're going to imply a contract, even though we know there's no contract there. We're going to create a legal fiction of an implied contract. If you don't have something in writing, if you have something in writing, we will be happy to enforce it. But if you don't have something in writing, we're going to make something up just so that you guys get over it, and don't clog up the courts too much. That's really just in California. Everybody else is pretty much like you were grown people. What were you thinking? You had marriage as an alternative and you chose not to take it. You're on your own. Okay? All right, so that ends chapter 2. You have your discussion and your assignment. I will be posting a test on Friday over chapter 2 that is due by the end of the weekend. So please go on to Blackboard, make sure that you look for the test, make sure you complete it, make sure you get it to me on time. Okay? And any questions, feel free to email me. Thanks.